Welcome, everyone. I'm Justin Paperny with White Collar Advice. Super grateful to have our good friend and terrific lawyer, Diane Bass, return to our channel. Hi, Diane.
Hi, Justin.
I want to talk about mitigation. Some people presume there's nothing you can do to mitigate, and there are some people who go to trial and are convicted and presume because they've gone to trial, there is truly nothing they can do to mitigate because they've convicted. So I want to get some of your insights on sentencing mitigation and actually go through a client of yours, despite being convicted at trial, got a great outcome. So jump in and welcome back.
So I just had the most extraordinary result post-conviction after trial for a client who I honestly thought was facing a 10-year mandatory minimum and wasn't sure that there was anything I could do for him. And it just worked out so incredibly well. And it's because of all the stuff that you and I always talk about.
So let's talk about that. You have someone that retains you, knowing that 98% of people are convicted at trial or plead guilty. We all know these statistics. And I know you went through these odds with him. He still said, I'm innocent. I'm going to trial. I'm prepared to endure everything that accompanies going to trial. Is that kind of how it happened?
Yeah, absolutely. I mean, his wife and I told him 100 times, look, if you're convicted, you have a 10-year mandatory minimum. If you take the deal before trial, there's a chance you might not do any time. Plus, he's not a citizen. He could have been deported. So all of the odds were stacked against him, and we still prevailed. It was incredible.
It really it really takes courage to go to trial because let's talk about that in a moment. So you prepare him for the odds of prevailing at trial. He actually goes to trial, and as I understand it, he was convicted. Is that correct?
That is correct.
So how long did the conviction take? Some people joke I went to trial, I was innocent. It took them about 7 minutes to convict me. So how long did that process take?
This jury came back after 4 hours. And honestly, it was about 4 o'clock on Thursday afternoon. So we thought that the judge was just calling us back to let us go for the day. And then they said that they had a verdict. So that was scary. And you can always tell when the jury comes back in if they're looking at you or not, what the verdict is.
So you have an idea what's coming. He's most likely going to be found guilty. You've touched on something that it was really profound. You had mentioned during the trial, it's an opportunity for the judge to analyze and assess the defendant. You said it's almost like a mini sentencing hearing. Can you discuss that? Because it can provide some hope to people who go to trial who may lose, but they want to know, like, hey, maybe some of the trial work could influence the ultimate sentence. Can you discuss that, please?
Absolutely. So one of the key factors when you take a plea is you get 3 levels off of the sentencing guidelines for acceptance of responsibility. If you go to trial, you don't get acceptance. However, the judge gets to see all of the evidence and really truly understand the client's role in the offense. And in this case, what the judge said at sentencing was that it was not a frivolous decision to go to trial. So he respected my client's decision to go to trial. Unfortunately, there was some evidence that pushed the jury over the edge. And you never know. This is what I tell all of my clients. You just never know what a jury is going to do.
Part of the reason our team refers so many of our clients to Diane is because she embraces the idea of mitigation. She doesn't have a God complex. She believes in advocacy. And I share this because there are lawyers who will have a client convicted at trial. We saw this. There's so many cases. The R. Kelly case, I think Elizabeth Holmes' messaging was off. I think Sam Bankman-Fried's message was off. They're afraid to convey the appropriate message to a judge for fear that it could jeopardize their judicial right. You viewed it differently, and you said you still need to mitigate in front of this judge and show him who you are and what you've learned. Talk about the value of mitigation, even if you're convicted at trial.
So my client had, first of all, a courtroom full of family and friends. There were at least 25 people there. They took up the whole side of the courtroom. They all wrote letters, and the judge commented on their letters about how much they loved, adored, and respected my client, and how all of them said something different. This is something that comes up. I know you deal with this, is that if one person writes all the letters and they all look the same, the judge isn't going to give them much credence. Where in this case, you could see that each letter was written personally by each person. What I also did in this case was I filed his wife's letter separately as Exhibit A, as opposed to see character letters attached as Exhibit B. His wife was discussing the fact that they had young children who were 2, 4, 6, and 11, and how bereft they were at their father's absence, and how she couldn't explain it to them because they were so young. And the judge commented on that as well, and how they were really suffering financially without him because he was the breadwinner. So that was a really, really significant point. Also, he wrote a letter and also made a statement, an allocution at the sentencing hearing, and he apologized for his poor judgment. So he wasn't admitting guilt, but he said he should have known, he should have been more aware. He did, in a sense, admit to willful blindness or deliberate ignorance, which are terms of art that we use, but there is a jury instruction in the Ninth Circuit that says if you were willfully blind or deliberately ignorant to the facts or to the fact that you were committing a crime, it's as good as being guilty. It's a terrible piece of law. It actually, I think, changes the burden of proof. But in any event, my client was willing to apologize to the court for his poor judgment. The judge said, "You didn't do anything to me, but the fact that you're apologizing to your family really means a lot. And I know you're sincere." So it was a really, really powerful, powerful hearing.
What did the government ask for?
The government asked for 57 months, and let me explain that. So he had a 10-year mandatory minimum. I asked the U.S. attorney after trial if she would do what we call a safety valve proffer. Safety valve is a statute and part of the guidelines that allows somebody with no criminal history to go below the sentencing guidelines. And without safety valve, unless you're cooperating, you can't get below the sentencing guidelines. During the course of this proffer, and I've had a long-term relationship with this U.S. attorney, she's very reasonable, very professional, so she allowed us to do this, which was extraordinary. And during that proffer, my client said, "I had a feeling, I was suspicious, but I didn't really look into it." So he admitted to willful blindness, which gave her the opportunity to say, "Okay, I think you're being honest," because that's the number one rule in any proffer, is you have to be honest. And so she gave him safety valve and she gave him minor role. Pre-trial, she had offered him minimal role, but she didn't go that far after trial. So she ended up offering 57 months, which is well below the 10-year mandatory minimum.
So they ask for 57 months. Clearly, everyone mitigates. His narrative. He has his narrative, his sentencing statement, a lot of character reference letters with the right message. It's stunning how many letters we review that have the wrong message, that don't speak to someone's character or the consequences that would continue to follow if they're in prison. So letters do matter. They asked for 57 months. What was the ultimate sentence?
So my client had been taken into custody after trial per the statute. The judge has to take them into custody. He had been in custody for 6 months as of the day of sentencing, and he went home that night. He got time served. I have chills just talking about it. It was the most extraordinary moment. I had chills again all over. I grabbed my client and hugged him. Everyone in the courtroom was crying. The judge commented that he knew that but for his relationship with the main defendant in the case was his brother. He said if it had not been his brother, he would never have been involved. And again, commented on all of the factors that we argued in mitigation. And he did the right thing. He gave him time served. And I have never seen that happen before.
I think that the takeaway is even if you go to trial and are convicted, you still have to mitigate. You still have to invest the time. Some people get that bad outcome and they do nothing. They pack it in and they convince themselves there's nothing they can do to influence this judge.
100%. And I want to say something else. You know, the wife wrote a letter. When I get letters, I'm going to read the letters and make sure that there is no message that they're sending the wrong message. So I will go through and I will go through the letter with the person that wrote it and say, "I don't think this is appropriate. Is it okay if we take this out?" I'm not just going to edit it for them or write it for them, but I am going to go through it with them and say, you know, maybe this isn't the message we want to send. Why don't we talk more about this? And if they're comfortable with that, then they'll do that. So these letters all wound up being just extremely powerful, and the judge could feel the respect and the love and the admiration. He knew how hard my client worked because that was all part of the trial. And again, it was just extraordinary.
Something as you interview and hire lawyers, you should listen to a lot of things that Diane has said. She's vested in reviewing the letters. She's really vested in the sentencing memorandum. And I know because we've had so many cases together, you share the memorandum with your clients well before it's due and you seek their input and guidance. You encourage them to do the narrative and mitigate, because so many people in our community will reach out and they'll be like, hey, I just got my memorandum. I don't have time to review it. It's due in about 15 minutes. They're not vested, and it's frustrating, and they feel helpless. So I think you can hear Diane's passion, but she believes in getting her clients vested and encouraging them to work and to really influence the what can be some really cynical judges. So Diane, it's a wonderful outcome. I think whether it's a drug case or a white collar case, it's all the same. You've got to advocate and invest the time to show why you're worthy of leniency. With that said, I'm going to leave the last word to you.
I think what my client said also was very powerful. I always encourage my clients to prepare their statement to the court, but then to just use it as an outline. I don't think that judges appreciate you reading something. I've already filed the letter that you wrote, so you don't want to repeat what you've said in your letter, but you want to look the judge in the eye so he can feel your sincerity. And in this case, obviously, he really did.
You've heard our team referencing our new directory, Top WCA or Top White Collar Attorney, which features just a handful of lawyers in each of the 94 judicial districts. Of course, Diane is one of those lawyers here in California. So if you need a lawyer, call. We're grateful to work with her. Diane, congratulations on the outcome, and thank you for joining us today.
Thank you, Justin.
Of course.